2021, you could not evict them for not paying the remainder 75% of the rent. So the basic structure of that hasn't changed. What has changed is that the January 31st date has now moved out to June 30th. And just to be clear, again, they do not have to pay the 25% of every month, each month as it goes. This is a common misconception that we ran into a lot. Everyone was saying, well, they didn't pay me the 25% in September or November or January. Well, they don't have to. They only have to pay the 25% at the end of the transition period, which is now June 30th. So if you have a tenant who didn't pay by January 31st and you were expecting to evict him, you can't, right? If you do the math, by the end of June 30th, it's about 2.5 months of rent. I think, I'm guessing that a lot of the tenants who had trouble paying are probably not going to be able to come up with this. And while this has kicked the can down the road, I think it's also made it more difficult for tenants to comply with this rule and avoid the eviction. So my prediction is that come July 31st, a lot of people who wouldn't have been evicted February 1st, because they did come up with 25% of 5 months of rent, are not going to be able to come up with 25% of 10 months of rent or 9 months of rent. And those people are going to be subject to eviction just because they didn't plan it out correctly. So another big question is the governmental rent assistance. How do you get this money? Right? Because as you probably have heard, the government put out a program where you can get up to 80% of the rent that was missed from September only through March, right? This is just something people need to, I'm sorry, it's from last March, April 1, 2020 through March 31st. Doesn't really go, the 80% doesn't go beyond that, just so everyone understands. How do you get this? How do you apply for it? The answer is right now, you can't. If you see the informational notices, which we'll talk about in a second, they specifically tell you to tell your tenants to call a phone number or go to housingiskey.com, which is a government-run website. And if you go to that website and click through a couple things, you'll see they don't even have the application site up yet. Under the law, they don't have to have it up until March 15th. I guarantee you it will not be up before March 15th at the earliest possible. And hopefully they'll comply with the law. If they don't, there's not really anything anybody can do about it. So if it comes up on the 17th or the 18th, or the 20th, so be it. But when the applications are up, by the way, you can apply for your tenants. Obviously, they have to cooperate with you, and you have to cooperate with them. And that's also going to be an important thing to discuss later when we talk about collecting this debt. Now, in terms of how it works, if you take 80%, the only way you're getting that money is if you agree to forgive the other 20%. And when I say forgive, it means forgive forever. Not that you can't evict them for it, you can't collect it at all. Right? So you're basically giving them a 20% break on whatever months of rent you're taking 80% for. Every single one of my clients who's asked me, I tell them take that deal in a heartbeat. Because if tenant hasn't paid you and they're willing to go in with you on this, you're going to see if you're getting 80%, you're getting a lot more than you would otherwise get from that tenant. So if the money's there, you can get 80%, take it. Now, what happens if you don't want to take the 80%? Maybe it's a high net worth tenant living in an $8,000 a month apartment who's just trying to abuse the rules, and you're not having it. If you reject the offer, they can still get 25%, okay? But the other 75% basically you can collect as a debt, right? And so we'll talk about how that works. There is a kind of priority list of people in terms of who they're going to help first, second, and third. First, they're going to help the people who have households with less than 50% of the area median income. And again, as we discussed, that changes depending on where you are. Then they're going to help communities disproportionately impacted by COVID-19. Who determines that? They do. So basically, they'll just publish a list and say, these are the people and these are the communities who are tier 2. And we won't know that until they publish the list. And then level 3 is basically any household with household income of less than 80% of the AMI, or area's median income. It's obviously going to be based on 2020 statistics, not on the 2021 statistics. All right, so the informational notice that we just discussed, if you'll remember when AB 3088 passed, in addition to doing the 15-day notices, if you wanted to, you had to give an informational notice to anybody who was late or in arrears on their rent. And the information notice basically provided them a notice of what their rights are under these tenant protection laws. So you have to give out a new one of those, right? And it's largely similar to the old one, but again, you have to give out the new one because it updates all dates and adds the information about the governmental assistance. You must provide that by February 28th, 2021, right? And these forms are readily available. If you don't have them, again, please feel free to contact our office. We can help you out with these. All right, small claims. So as was provided in AB 3088, when the end date was January 31st, starting March 1st, a landlord could go to small claims and collect any of the COVID rent, right? And they did this specifically, again, because they wanted to avoid the taking issue. Why do they say small claims? Because if you go to regular court and your landlord is an LP, an LLC, or corporation, anything other than an actual individual, you need a lawyer to represent you in regular court. An entity cannot represent itself in court. It's not allowed. It's illegal. The judge will just dismiss the complaint. A lot of landlords are smaller landlords. Not everybody is, Goldrich and Goldrich Guest. Not everyone owns 5,000 or 10,000 or 20,000 units. Some people just own 4 or 5 units, and that's how they live. So for them, going out and hiring a lawyer to go collect $10,000 or $15,000 of rent is not feasible. So the legislature said, all right, fine, we'll open up the small claims courts for that. Why is this important? Just so you understand, most times in small claims, if you're an entity, you can only collect up to $5,000 per case. And you can also only go 2 times every 12 months. Well, if you have $10,000 to collect on one particular tenant and you have 5 tenants you need to go collect on, that's very limiting. And small claims doesn't really provide you much relief. And again, small claims is important because you don't need a lawyer to go to small claims. You can go by yourself. So the legislature said, all right, fine, we'll answer that as well. If you are collecting COVID debt, you can ask for as much money as you want, as much money as is due. And if you are collecting COVID debt, you can file as many small claims actions as you want to. So both of those limitations are removed. Now, before, the date was March 1st for a January 31st end date. Everything is moved over by 5 months. So now you can go to small claims starting August 1st. Now, as another option to small claims, and one that we have been suggesting people use not for collecting rent, but for using the only avenue you have to put pressure on tenants, you can, even today, go to regular civil court and file a regular civil action, whether in limited civil or unlimited civil, depending on how much money you are asking from the tenant, and sue them today. Now, there's no limitations on that. However, what they added in SB 91 is that you have to provide evidence that you either you made a good faith effort to investigate whether governmental assistance is available, that you have sought the assistance of the government to pay for this rent with the tenant, and or that you've cooperated with the tenant's efforts to obtain this rental assistance. How do you meet that burden, right? Well, right now it's very simple. All you do is you say, I went to the housingiskey.com website. I looked to see if it was available. Nothing's available until March 15th. You've done literally everything you can because no one can apply for it. So if you want to sue your tenant right now, now's the time to do it when the court really can't fault you for not doing more because there's literally nothing else you can do, right? So you just have that simple declaration and you've met your burden as far as we can tell. Does that mean every judge is going to buy that? No. Right now, just so you understand, I don't know how many of you have experienced this, but in the courts, it's a little bit of a Wild West situation where you have judges and even clerks making up their own rules, applying law how they see fit, contrary to what's written, and sometimes writing in things that don't exist because they can and because they're applying their own opinions as to what should be happening into the world and forcing you to comply with those opinions, even though they're not lawful. For example, we tried to do a UD in Long Beach. The tenant did not respond. We sent in a default. Default was rejected for no reason. So we called the clerk and said, why'd you reject the default? The Long Beach clerk said, our boss, and remember the boss is not the judge, the boss is just the senior clerk in the office, said we're not doing defaults on UDs. Why? Because that's just what they said. Now, is there any law that says you're not allowed to default on a UD right now? No. They just kind of made that up because that's their opinion. Someone in that office doesn't think it's right to evict people during COVID, so they made something up. Now, what can you do about it? Not a whole heck of a lot. You'd have to go and either file a lawsuit or make an official complaint to the judge. It would take a significant amount of effort. Somebody's willing to do that and pay for it, it can be done, but most people won't. And I think a lot of the civil servants understand that. They know that. And so they know they can get away, at least for a long time, with doing whatever they feel is right according to their own moral code, regardless of whether it's written down in the law or not. We have judges who are letting tenants skate on not filing the declarations, saying that they are impacted by COVID. We have judges who are basically letting high net worth people skate without providing any evidence of the fact that they were really impacted by COVID. We have a court in Oakland who is still trying to make people comply with the emergency rules that were lifted back in September. We have seen a myriad circumstances where the courts are really just not enforcing the rules. And because they know it's a temporary situation, they essentially know they can get away with it. And there's not a whole heck of a lot you can do about it in the short amount of time you have, even if you want to take an appeal. So I'm saying that kind of as a public service announcement to help you guys understand that even when you're in the right under the law, it may not be that easy to get past what some people's opinions are of the law and how they're going to choose to enforce it during what are in our generation's unprecedented times. Okay, so some of the rules that are still in place in terms of from AB 3088 to the SB 91 is that high income tenants, people who are making at least 130% of the average median income, still have to provide proof of their inability to pay, as opposed to people who make less than that. They can just sign the declaration and it is basically self-certification. You can still, in most jurisdictions, not all, but most, you can still proceed against licensees and squatters. That basically means, let's say you have someone who's living in your unit because they're the key holder or they're the on-site manager. They're living there for free. They're living there basically just because they have to as part of their employment. And now you fired that person. They're not a tenant. They've never paid you a dime of rent. Don't collect any rent from them. But as long as you meet certain guidelines, that person is just a licensee. You can still evict them in most situations. Also, of course, if you have squatters, this is becoming a very, very big problem in a lot of places because a house will become abandoned. The homeless population is going up. And so homeless people are taking over houses and apartment buildings all over the state. Of course, you can still proceed against them. Now, no fault evictions, that basically means things like 60-day notices to terminate. They cannot be filed until July 1st, 2021. Okay. That applies to all properties, rent control, non-rent control. No fault evictions includes Ellis Act, landlord or landlord occupancy, resident manager. So even for someone who has a house and is renting it out for a little bit of time, has a tenant who doesn't want to leave and wants to come back to their own house to live there, they may be out of luck. And so in those kind of situations, that's where we start to use alternative measures. One is just a standard cash for keys. Pay the person to leave. Sometimes it's a lot cheaper to pay the person to leave than to wait for them to leave or to wait until July 1st or hope they pay some rent or whatever else it is you want to do, depending on how much, of course, it is that they are asking you to pay them. Another thing that we do is we file the civil collections cases that I had mentioned earlier in order to put pressure on the tenants. A lot of tenants don't necessarily understand the intricacies and the difficulty of collecting a judgment, whether it's $5,000, $50,000, or $100,000. Judgments are hard to collect, but judgments are not hard to end up on credit reports, right? And being in a lawsuit for a regular person is a scary thing. It's just when a regular person who doesn't deal with the law on a regular basis knows and understands and is getting served with a document that's saying somebody is suing them, you have effectively put a lot of very effective psychological pressure on them. And that provides you with, even though this sounds kind of harsh, it provides you with some leverage to be able to make a deal with them. Because realize that without this particular leverage, without taking these actions, the law has provided 90% of the leverage to the tenant. They feel extremely empowered, probably more empowered than they actually are. But basically the media has been telling them that the government has their back, and to a large degree they do, right? But you need to utilize every tool that is left in order to service your landlords, your investors, whoever it is that you're working for, to basically help maximize whatever collections it is and to fight back against people who are abusing the system. I'm not telling you to go out and sue every tenant who can't pay the rent. I think that there are a lot of people who come to their landlords, come to their managers and say, look, I have a problem. I can pay this much, or I really can't pay at all. Can we get on a payment plan? Can you help me out here? Can you help me out there? And for people who come and communicate with you, I think it behooves you from a public relations perspective, from a legal perspective, from a saving on legal costs perspective, and even maybe from a moral perspective, to work with those people. However, not everyone is like that. A lot of people are just ghosting their landlords and managers. A lot of people are abusing the system. They work somewhere, they make money, and they're just choosing not to pay the rent because they hear in the media that they don't have to, right? We've had situations of restaurateurs who are renting $10,000 a month condos who are saying, I don't have money to pay the rent. And then you show up and you see them drive away in their brand new Mercedes or Lamborghini. That's a real story. I'm not making that one up. That's a real story, right? For those people, there's no real reason to treat them mercifully. They're abusing the system. You have to fight back. And so that's where we utilize things like filing the civil actions, because it puts pressure on them. That's pretty much a summary of everything that happened in SB 91. I'm sure that a lot of you have questions. I'm going to go over to the comments and see if I can answer some of these. Okay, we had a question about pets. If somebody hosts or adopts a dog cat during the pandemic, and the property traditionally charges pet deposits and pet fees, are the said pets during COVID exempt from the pet fee? Probably. There's nothing in the law that specifically says you can't charge them the pet fee, but essentially they might claim that you're discriminating against them because they have to have the pet. So right now, I would say to err on the side of caution and not try to charge the pet fee, so long as the pet is not destroying the place, obviously. Another question: if you do take the 80%, the resident is relieved of additional rent, and this would void any potential eviction status. Correct. Theoretically, maybe. If you take the 80%, remember you are forgiving the other 20% of the rent, but you can only get 80% up through March 31st, right? If they have unpaid rent from before April 1st or from after March 31st, because you might not get the money until after, right? That doesn't absolve them of whatever they have to pay starting April 1st of 2021. And this is actually a very important question, because remember that if you take money from the tenant after you issue a 3-day or a 15-day notice, you are waiving that 15-day notice. That 15-day notice is now invalid. So be very careful when you have people who owe money to understand what the impact of taking even the state assistance will be. And again, these are individual circumstances where it's best that we have a conversation and figure it out correctly. Also, again, take into account if you have someone who hasn't paid, but they're also having you have a nuisance situation with them, or you have an illegal subletting situation. Once you take money, you're voiding your right to evict them on that after you already know about it. So you have to be really careful about these situations. And again, it's best to speak to an attorney about those unique circumstances. Right. So Rick is asking, if an owner wants to move in and offers cash for keys, what would be needed to make sure the tenant doesn't turn around after the fact and cause problems? So Rick, I don't know if you're here, if you want to just unmute yourself so I can ask you a follow-up.
Go for it.
So when you say after the fact and causes problems, you mean after you make the deal with him or after you even make the offer?
The deal. So, right, because to your point, like they don't have to accept it. So
right.
Let's say they do accept it, they take the cash and move on, but then they find out later, oh, I couldn't find anything. Oh, because technically you weren't allowed to, kick me out, but you accepted the cash. Like what would you need to make sure nothing would happen after the fact?
Well, you stick to the name of the deal, which is cash for keys. Most of the time, we do not give them a penny until they actually are there to give you the keys and sign an affidavit of vacancy, basically saying,
got it.
Notarized, I have left. A lot of the times we do the cash for keys through our office or through an escrow, so that when they come and pick up the money, right, there's a notary there to notarize their affidavit of vacancy. So they've left, they've given you the keys. By the time they get the cash, they're not a tenant anymore. So they can't really cause any problems. Now, a lot of the times the tenant will come and say, it's nice that you're giving me $10,000, but if I don't have the money in my hand, I can't put down a first month's or security deposit or even get the moving fees paid. No problem. What you do in that situation is you say, show me your signed lease and show me who your landlord is or the management company is. I will deduct that $10,000 and write a check directly to the landlord. Now you're doing this before they leave, but it is a risk well worth it, because once they have a signed lease and you're giving the money to the next person, it's not in their hands, it's very likely they'll just go to wherever it is they're planning to go. Because the only way that they can take advantage of that aspect of the money that they agreed to take is by going, right? Their first months and their security deposit is somewhere else. If they don't go to somewhere else, that money is gone. You're not going to give it to them, right? So that's the only way they can actually take advantage, is by doing the deal as they agreed to, right? And that's basically the rules for how it would work with an Ellis eviction in the city of Los Angeles. Anyway, that's why we tend to follow these, because for once the law is actually pretty well thought out, right? You want to encourage the tenant to leave. That's why cash for keys really works, because it really gives the tenant an incentive to go, and it gives them a mechanism for how to go. Remember, it's really, really important to make sure and to understand from the tenant's perspective that if you're telling them they have to leave, a lot of the times they stay not because they're not afraid of the eviction, but because they really don't have a way to go, right? There's literally no way they have the money for the first month's security deposit, so they might as well just stay as long as they can, right? So you need to empower the tenant to do what it is you want them to do, which is to leave most of the time. So that's how we avoid them causing problems. There are certain places where they also have a right to rescind the agreement. We don't pay a dime, not to the landlord, not to the moving company, not to anybody before the rescinding period is over. In LA and, for example, in Santa Monica, and I believe in West Hollywood, it's 30 days. And so you specifically write that into the agreement. Under no circumstances are we advancing any money before 30 days, because before 30 days, that agreement doesn't mean anything. Right? You need to wait until that 31st day comes. All right.
Thank you.
No problem. So Diego says, can we start posting 3-day notices to tenants who have not claimed COVID-related financial distress? If it's for non-payment of rent, no, not really. What you have to do is you need to still be posting your 15-day notices. And remember, those are 15 court days, right? And if they don't respond, then you can assume that they have no COVID-related financial distress and file your eviction. Remember, of course, that after you file the eviction, they can still come to the court and say, oops, I didn't understand. I didn't really get it. I didn't really read it. I was out of town. My dog was sick. I was having surgery on my toe, whatever it is. And they can come with the declaration in the court and give some sort of excuse, and the court may very well dismiss the case. And at least in LA or Santa Monica, the judges almost definitely will dismiss the case. In San Bernardino or in Riverside, they may not buy whatever the tenant is trying to sell that day. So it really depends on where your particular premises is located. But no, 3-day notices for non-payment of rent, or even to cure or quit for other non-payment of funds that are otherwise due, don't work right now. 3-day notices do work, as we talked about, for other cure or quit, other breach of lease, non-monetary, or for nuisance. Another question is, to confirm, I can start eviction on a resident subletting that is not COVID related, although they are in arrears. Yes. So if they are truly subletting, so if they have flown the coop and someone else is staying there, right, regardless of whether they're paying the rent or not, you can evict that person because they are illegally subletting. There's a big difference between letting someone stay because that person got kicked out of their apartment because of COVID, right? Like having a guest for a few months, and just moving back to New York and saying, hey, my friend Stephanie is now your new tenant and nobody's paying the rent and you don't know who Stephanie is. That they're not allowed to do. That's called illegally subletting.
Could the non-tenant claim COVID?
Say again?
Could that tenant claim COVID even though they're subletting?
No, because the apartment is not theirs to just pass around to whoever they want, right? And I understand it's kind of a subtle difference, but the fact of the matter is, if you're not living there, right, then you're certainly not allowed to just give the apartment to someone else. If you can't pay the rent, you're certainly not allowed to sublet one of the rooms and get rent from that. None of that is legal. Even if it's because of COVID, even if it's because you need extra cash because of COVID, even if because the person who's living in the sublet room is only renting that room because they couldn't afford their last apartment, right? None of that matters. You're not allowed to sublet. What you are allowed to do is basically bring someone in. Now, you might have the exact same factual circumstances on the outside, and it might be one or the other. Most of the times you can figure it out. If you can't figure it out, a lot of times we just say, file the lawsuit, and if they can claim a defense, let them claim the defense. Most of the time it's not. I mean, to be honest with you, I have not seen virtually any situations where someone is saying, oh, my friend had to live with me or my parents had to live with me or something like that. It's just really not happening that we're aware of, that anyone's bringing to our attention. Most of the time it's someone has left and decided, hey, all apartments are free, Wild West, right? Hey, Bob, come live in my apartment. No one's paying for it anyway. That's illegally assigning or legally subletting. That doesn't work.
So if the subletter has established residency, does that matter?
There is no such thing as establishing residency. You're
Okay.
either there legally or you're not there legally.
Okay,
It
perfect.
doesn't matter if you're there for a day or a month or 6 months. You know, if you told the New York Times to start sending your newspaper there, that's not a defense to illegally subletting, right? So the important thing is do not take rent from the subletter. If you take rent from the subletter, they are now your tenant.
I
right?
haven't.
Right. And the worst part is they're your tenant with no written lease. So once you take rent from a subletter, you're putting yourself in a very dangerous and precarious position. It's very important when you take money, you know who it's coming from. All right. So can you please clarify regarding the no late fees? Does this only apply to those who have claimed COVID? Not really. I would just, if you have someone who, let me clarify. If you have someone who's paying the rent regularly and you want to, charge them a late fee and you think they're just going to pay it because they paid 4 or 5 days late and they don't give you any flack for it, okay, charge the late fee. If they ask you anything about it, if they say, hey, you're not allowed to charge this, don't get into a conversation about it. Just waive it, right? But it doesn't hurt to try. Certainly, we're not going to evict about it or include it in any notices. But nothing's going to happen to you if you try, and if they pay it, great. If they don't, fine, no big deal. What kind of backup do we have to have in order to prove subletting? I mean, you don't necessarily have to have the actual contract. There very rarely is one. In obvious situations, someone's put their extra room on Airbnb or VRBO or something like that. For that, it's good to have the actual printouts of the website showing that they're advertising the unit for sale or for rent. In terms of if it's not that situation, look, if someone's there and you are at least aware of the fact that they're not there for COVID-related circumstances and it's just a random person, most of the time we can just proceed on those grounds and see if they come up with any defense. Most of the time they don't. So it's a kind of a hard situation to have official proof, but if you really want these people gone, there are methods during the eviction process. Remember, an eviction is a lawsuit. You're allowed to do discovery in the lawsuit. So you're allowed to go and start asking them and, show me the evidence of why this person is here. And if they can't show you the affirmative defense of that the person's here because of this particular COVID exception, well, they're illegally subletting or they're illegally assigning, because subletting implies that they're renting it out. An assignment just means that they're giving it to someone. They don't necessarily have to get paid for it. So either one is not legal if your lease specifies that. So you always have to make sure you have a good written lease. All right, if a tenant receives a partial rental assistance, will they still have to submit a declaration for the remaining balance owed? So if you're talking about the 80%, no. So once you take the 80%, the other 20% doesn't exist anymore. You are basically giving them an 80% discount on whatever rent, a 20% discount on whatever months of rent they are paying you for. So once you take the 80%, they are paid in full. There is nothing to submit a declaration about, right? They would only have to submit a declaration if we're talking about rent that isn't covered by that 80%. So next, what if a resident has a guest due to COVID-related circumstances and the guest extends the stay and starts receiving mail? Is there some sort of squatter law that covers somebody who receives the mail if not formerly residing or listed as a resident occupant. Meaning, is the postal mail provides squatter rights? No, it's not really. There's not really any truth to that. It might be evidence, but the fact of the matter is most squatters have rights just by physically being in the building, right? So I had a situation where my client is a developer. They have 3 units over in Los Angeles. They Ellis the 3 units, which means they went through the expense of actually going through the entire Ellis process. This was before COVID, and paying the people who were there legally to leave, waited a time, paid the people left, the units were vacant. And before they even had time to put up a gate or put up the, cover the windows, some enterprising fellow who saw that the units were vacant decided to pretend he was the owner and listed them on Craigslist. People showed up and took leases from this enterprising fellow and moved into the units, right? Even though there was no electricity to the units. So they must have understood. But the fact of the matter is they had a written lease. So developers, people show up, they see there's people living there. They say, who are you? It's like, they say, we have a lease. John Smith gave us this lease. We tell them, we don't know who John Smith is. We're the owners. You can't be here. They say, sorry, we have a lease. Call the cops. And what the cops will do is they'll show up and they'll talk to the squatters, and the squatters will show them the lease. And the cops will say, this is a civil matter, bye. And they're not going to do anything for you. So that squatter doesn't have mail, doesn't have utilities, doesn't have anything. They're just physically present, and they have a fraudulent lease. We had to evict them as a forcible detainer, not as an unlawful detainer. So it's a lot less rights, but yet we still have to go through the process just because they wouldn't leave and the cops wouldn't take them out. So that's basically how squatters' rights works. In your particular situation, again, if you have a guest that extends their stay, even if they start getting mail there, that doesn't necessarily mean anything. They're either protected by the COVID exception or they're an illegal subletter. It's one or the other. And if they want to get some mail there, it doesn't really change anything. So I got to the end of the questions. Anyone else want to ask any questions? You can just pipe in and we can start a conversation, or you can write some more over there. Anybody else? It doesn't even have to be about what we're talking. It can be any sort of question that you have. This is the time to get it for free. Anybody else? Nope.
Yes, I have a question regarding service dogs.
Yeah.
My tenant, there's not dogs allowed, and he now has a dog, and he's saying it's a service dog.
Yeah.
So
there's not really much you can do about that, because if he says it's a service dog or an emotional support animal or something of the kind, remember, they don't have to be actually blind or actually deaf to get a certificate. It could just be an emotional support animal, and they can go to their local doctor and for $100 or $200 get a certificate or a letter from a doctor that says that.
but he has to show me that, right?
Correct. So you can ask him and say, fine, if it's an ESA, emotional support animal, just show me some documentation that says that. Now, and if he doesn't even want to go to the minimum effort to actually get this very easily obtainable certificate, then he's violating the lease.
Okay.
And he's lying to you. So you can evict him for that.
All right. Thank you.
All right. Anybody else? No? All right. Oh, got another question. In regards to the 3-day notices for rent, do we serve them now or do you not recommend? So again, right now, you can't really serve anybody with a 3-day notice to pay rent. If we're talking about a monetary obligation, you have to use the 15-day notices and give the tenants an opportunity to give you back the declaration that says they can't pay due to COVID-related circumstances. So 3-day notices to pay rent or 3-day notices to pay any monetary obligation under the lease until June 30th are a no-go anywhere in the state. Okay, what are the 15-day notices called? Sorry for the obvious answer, but they're called 15-day notices. If you're talking about where are they available, we have some of them. You can get them if you're a member of CAA. You can get them if you're a member of AGLA, which is the Apartment Association of Greater Los Angeles. There are a number of real estate associations that have copies of them. If you're having trouble getting your hands on the proper forms, give us a call. I'm sure we'll be able to help you out and also assist you in making sure that you are filling them out correctly and serving them correctly, because all of that is a necessary prerequisite to having them be of actual use in an unlawful detainer. So if there aren't any more questions, just wanted to let you know how you can reach us if you have any more questions or if you need us to help you out with anything. So our website is davidovichlaw.com, right? You can see all the attorneys that work for us over at the /attorneys, davidovichlaw.com/attorneys. Oh, so we have another question. Hold on. Will a rent increase given to a tenant who claimed COVID be considered retaliation? No, so long as you're given the same rent increase to everyone. So you just want to make sure you are treating everyone the same way, and that the timing is so it's not discrimination. It's not it shouldn't be retaliation so long as, again, you're doing it to everyone at the proper time and you have a history of giving these rent increases. And so long as the rent increase is illegal, we're in your jurisdiction. No, it shouldn't be an issue. On the chat, we have some information. You can look up the COVID-19 update for February 2021. So a lot of this information is available there. And if you want to give us a call, the main line is 818-661-2420. If you want to reach me at any time, I'm giving you my mobile number. It's 310-877-2834. That is the best place to reach me for any questions or issues you might have. And I just want to remind everyone that in addition to our landlord tenant services, we also provide a full service, full plethora of services in real estate, construction, and other landlord tenant issues on transactional and litigation. So if you are buying a building, if you're selling the building, and you have purchase agreements, if you're doing loan docs, if you want to hire or fire a contractor, if you're having issues with a contractor or an architect or engineer, or if you want to update your leases, or if you want to get a more robust lease that is updated, not necessarily rely on what the form leases are, all of these varieties of different issues that are related to real estate and construction, we can help you out with any of those. And we'd love to do that. So yeah, there's my information on the chat. You can reach me by email, on my mobile number, on the direct number, however it is you'd like to reach us. We are more than happy to help you out. So if there aren't any more questions, thank you all so much for joining us today. I really appreciate it. This is actually our first official webinar, so I hope you enjoyed it. I certainly enjoyed sitting here with you guys and chatting with you. And again, if you have any more questions, just feel free to reach out. But have a great afternoon, everybody, and I hope to speak to you soon.